Please be seated. We'll hear argument in 2273, Cadence Bank against Elizondo.
May it please the court, Mr. Huttenbach will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. My name is Pat Huttenbach. I represent Cadence Bank. This is a UCC check case, and I believe the following question will be answered by this court. Is a bank customer who, ignoring many suspicious facts, ignoring many red flags, to earn a $10,000 non-refundable retainer for doing less than an hour's worth of work, who deposits a counterfeit check into their bank account, and then is that customer able to avoid the UCC and argue a common law cause of action to avoid liability? I think an important policy question for this court is, we have the Texas legislature who has enacted a specific code of laws over this exact area of the law, bank deposits and collections. And if under that law, the result is one thing, but then ultimately is an appellate court allowed to say, no, I can disregard that law, and instead I can focus on a common law cause of action? I think the court below erred for at least 4 reasons. The first reason is what I just talked about, the preemption. Does the UCC preempt such common law claims? The second is the court below erred because it created a conflict in Texas law. The American Dream Team case, under pretty analogous facts, said that the bank should win in that case, and the court below said that the customer wins in the case. That conflict has now created confusion for banks on how to handle such deposit issues.
But isn't there a difference here in when typically a bank would be entitled to a chargeback when there was a dishonored check, because there was a contract here between the lawyer, the customer, and the in other words, $55 was paid in exchange for the wire transfer. Doesn't that make a difference?
Not necessarily, Your Honor, and the reason I say that is because I think the court below, that's my 4th point, but I'm going to jump to it now because you asked the question. I think the court below erred in its contractual interpretation analysis. Paying $55 was an administrative fee. That's not consideration to have a credited check be irrevocable. In other words, you can no longer, if the check had been returned, let's say it had been an altered check, can that check be returned? If, let's say it was originally finally paid under Reg CC. Can that check then be returned if they find out it's an altered check, or it's missing an endorsement, or it has a forged endorsement? So there's a whole bunch of other issues. I don't think the intent of that quote contract, it was a wire transfer request form, was to irrevocably say that the customer can never be responsible for depositing a counterfeit check again.
So how much consideration would need to be paid for it to be a contract that would make a difference?
Again, because I'm not aware of banks that do that practice of guaranteeing a deposit, I think most banks would be very reluctant to enter into that type of contract because, as you pointed out, you would need a lot of consideration to be able to afford that risk shifting. The request form is just a request form. It was not a full agreement. The deposit agreement is an agreement. The purpose of the request form was to gather information. And so I think that, I can get to it a lot further on if you'd like, but I think the contractual analysis of finding this new contract that superseded everything. I mean, what happened to the underlying deposit agreement? Did all those terms just go away? And it gets back to the preemption issue. If this common law argument exists that the new contract was created, well, that any customer then can then claim if they buy a cashier's check and they sign a form. Does that throw away all the UCC? The UCC is clear who's liability, who is liable in this case. So I think that's my 4th argument, was the contractual interpretation analysis, I think, is misguided. There was not a meeting of the minds. The third one.
Does the UCC say, to your preemption argument in section 4.214, what in there to you says that the bank cannot waive its right to charge back the check?
When you say cannot waive its right to charge back.
Right. That sounds like what your argument is to me, is that the bank cannot, by contract, waive its right to charge back the check. Is that your argument?
Well, the UCC, if you look at the UCC, what does it say?
It says the bank may revoke and charge back, which to me doesn't sound like, and then there's a provision further on that says the right to charge back is not affected by certain things, but none of those things apply in this case.
Correct. I think it goes to the underlying premise of the UCC. When you deposit a check into your bank account, you are making certain warranties when you deposit that check. You are warranting that you are entitled to enforce that instrument. You are warranting that all signatures on their instrument. So the whole purpose.
But the UCC doesn't make you rely on that warranty. It gives you a statutory right to charge back for a provisional credit. So it's giving you even more than the warranty. But what I'm asking is why can't the bank waive that right to charge back by contract?
I guess a bank could waive that right, but
Okay.
the UCC
So isn't
would.
that what we're about here in this case, is did the bank waive that right in the form that was filled out, which I understand you say is not a contract, but.
Well, before we get to the contract interpretation, to go to your question is, I think the UCC in comment 1.103 says that the UCC provisions they preempt common law claims. I mean, it says that in comment 2. And that.
Well, I understand that, but they only preempt to the extent that it's inconsistent with the common law, and we have a fairly high standard for preempting the common law. So what about, I guess that's the same question that I was asking you, is what in 4.214 is inconsistent with the bank's right to contractually waive its chargeback?
Well, if you go down that road, that a bank can alter the clear provisions of the UCC in a contract like that, what is the overall policy going to happen then? Because then any customer, to try to get out of the warranties that they've made under the UCC, is going to start claiming, just like in the American Dream Team case, the bank told me the funds were good. The bank told me the check had cleared. And in this case, the bank told me that the funds were collected.
But isn't that a problem if the bank does tell you that and that's not true? I mean, there are lots of other cases that have been cited in the briefs about where the bank did tell somebody that the funds are good, they've been collected, and that wasn't true. And in that case, the bank was not able to charge back.
It is a tough issue in American jurisprudence right now. But what I would say is that this court has said, who is in the best position to try to prevent, this is from the American Airlines versus Martin case. This court said, and I quote, it says, the UCC facilitates transactions benefiting both consumers and financial institutions by allocating responsibility among the parties according to who is best able to protect a loss. If the court ultimately rules that a bank can be liable in a case like this, banks are going to be extremely reluctant to provide provisional credits. So if it's an over $5,000 check, a bank might wait a long time. If a business deal has to get done, we're sorry. The Texas Supreme Court has told banks in Texas, be really careful about making provisionally credited funds available to customers. The problem with
But why couldn't they just be clear that it is a provisional credit?
Well, it's not just a provisional credit problem, because, again, that only gets us past the UCC midnight deadline and the Reg CC deadline. The other issue is that you'll know that within about a week. But these checks that are deposited in Texas, they can be a month later, a year later, up to 3 years later. If that's an altered check, or if that's a missing an endorsement or a forged endorsement, that check will come back. And how is a bank ever supposed to, if it's truly supposed to verify collected balance, how does a bank ever accomplish that?
Well, I don't know, but the CFR seems to suggest that collected balance means a payment for which, a check for which payment has actually been received. So the people who know better than me seem to suggest that it can be done. So that's where I'm a little bit confused.
And those provisions were changed in 2000 again to even make funds even more available, because the law wants banks to make funds available as quickly as possible. And so that's why those regulations have carve-outs for things like if it's in this case, if it was a new account or the bunch of overdrafts on the account, the bank might not be as willing to make funds available. So the funds availability is a big interest to Texas business. I think that the issue is there's a Reg CC issue on the Reg CC says the check is finally collected if it's not returned unpaid by the midnight deadline of the UCC. But that only takes one part of the equation. The second part is if it's an altered check, you're not going to know that for months later, or if it's missing an endorsement. And so if you're trying to allocate who's responsible if this check is not a good check. Are you really going to know that in a couple days? In most cases, no, you're not. Most cases, it takes a long time.
And it seems like these rules cover the bank in that situation as long as you don't tell your customer that the funds are that the funds have actually been received.
And that's a good point. I mean, the UCC was changed in 1996 because right now, this is the law in Texas. The law says the bank can reverse that even if the customer has spent it. But the law changed the UCC. It used to be very strict liability or strict, interpretation up until 1996 when the Texas legislature said, you know what, we need to put some wiggle room into the statute. And so for the imposter rule, for the employee responsibility rule, for the repeat wrongdoer rule, they built in a good faith standard into the UCC that a bank, if you don't act in good faith, you could be liable. But this statutes that we're talking about don't have that good faith standard. It is if you deposit this check, you are warranting that this check is a good check. Period. That's what the UCC says. There's no good faith standard. The legislature could amend the UCC in Texas, as it did back in 1996, and build some of those things in and have some exceptions. But the UCC, this is the law that we have today. And the reason why it's rigid is because if you start getting into, well, is this really a contract? Is this possibly change the law? Then what are banks supposed to do with individual checks? And to get back to the earlier question about, is this really a contract? But then what does the bank have to do to, quote, verify a collected balance? Cadence truly believed, with this wire transfer request form, that the reason it thought it needed to verify a collected balance was to protect itself, not to protect the customer. If you write a $100,000 check and there's only $1,000 in the account, that bank is probably not going to pay that check or give you credit, allow a wire transfer to go out. But if you want to do I think I misspoke there, but if you want to do a $100,000 wire transfer and you have $200,000 in the account, the bank can say, oh, that you have enough funds in the account. But if you truly extrapolate that and say, well, collected means you've got to call another bank, who are you going to call? A teller over there? That bank's going to have to call their customer. Is this really a good check? I don't know. What if the check had been a legitimately issued cashier's check, fraudster copies the check? So it's not a good one. But if you call the bank's going to say, it's a good check. We issued that cashier's check. So legitimate person could be negotiating the check. And meanwhile, someone that's defrauded receives a check, they think it's good, you call the bank, it's a good check. You've got all sorts of problems. But the UCC, the way it's set up right now, has these rules that allow you to follow and you know your liability. So I think those are...
And I think that's the point, is if you follow them, you know your liability. But if you waive them or if you say something inconsistent with them, then the question is, can't you be liable in that circumstance?
The way that the American Dream Team Court handled it was we're going to throw away all these the breach of contract, all these other common law claims. If the bank defrauded the customer in your situation, if the bank really made evil, improper representations, but the American Dream Team Court said, look, the customer, there's no reliance here because the customer had been told in the deposit agreement that the provisions of it's a provisional credit. In this case, he was handed, when he deposited the check, 2 pieces of paper, a deposit receipt and a deposit slip saying, this is subject to the UCC. He was handed another slip saying that this is a provisional credit. And so
How about when the wire transfer form was sent to Mr. Elizondo, was it already completed by the bank employee to fill in the blank that said collected balance? Was it blank or was that section already completed such that Mr. Elizondo could have relied on it?
It was blank, and if you look at the document that he produced in this lawsuit, it's got a Cadence Bank Bates number on it. He didn't see it until the discovery of this lawsuit. So he could not have known what the bank had done with that. All those reps on that form, he didn't see it until well after the events had happened.
Does the record reveal whether Cadence Bank provides a mechanism for a customer to log in or get more detailed information of his own accord about whether credit is provisional or not? In other words, can the consumer, rather than rely on something the teller may say or not say, does the consumer have a mechanism, a statement, something to look at to determine whether there's risk associated with the deposit he thinks he made?
Justice, my time is
You may
up, but
respond.
Okay. So to answer your question, there's a way to check an available balance with the bank. The problem with an available balance is there are all types of credits going in and out. You won't know that check is a good check that you deposit for up to 3 years. And you won't know it, your bank won't know it, the maker's bank might not know it, and their customer might not know it because they could get contacted 6 months or a year later that it's an altered check or something like that. So it would be very difficult to have a system of, are these truly collected or, as your question asked, funds? So.
Any other questions? Thank you, Mr. Huttenbach. We'll hear from the respondents.
May it please the court, Mr. Smith will present argument for the respondent.
May it please the court. Your Honors, Cadence Bank knew the very next day that these funds were not good, that the check was not valid, and that the funds had not been collected. We're not dealing with a 3-year situation here. This is the very next day. And I think there are 2 primary issues before the court. The first is, does it matter what this wire transfer request says? And second, what are the legal consequences? What does the form mean? Going to your questions, Justice Huddle, about the form as Mr. Elizondo saw it. But I'd like to start with the background rules of the UCC, of Regulation CC, the federal regulations, and of Cadence Bank's deposit agreement. We've heard a lot about how the sky is falling on the banking industry if we hold banks to their own contractual obligations. That simply is not the case. As we've shown in the bench exhibits, the UCC says time and time again that parties, including in banking relationships, may alter their obligations by agreement. Agreement is a defined term in the UCC. We aren't dealing with preemption in the least. To the contrary, Mr. Elizondo stands on the black letter of the UCC, on the black letter of the federal regulations, and on the black letter of the deposit agreement that Cadence Bank relies on.
But the opponent has argued that the $55 fee was not really an agreement to alter the contract. It was simply paying for administrative costs, which was a very small amount. What's your response to that?
2 responses. First, the document doesn't say that, and that runs contrary to centuries or century and a half of Texas case law. Merely a peppercorn can serve as consideration. And if we're going to argue about the rationality of the size of the consideration, that's not for the courts to second guess. Mr. Elizondo agreed to pay $55. That is undisputedly different from the consideration set forth in the deposit agreement. It's in the bench exhibits that we've provided. It's a $45 fee under the terms of the deposit agreement. But the deposit agreement also says repeatedly that we can set forth additional terms and additional disclosures governing the services that we may provide. And note the second page of tab D that we've provided to the court is a key example. It says that the agreement includes new or amended terms and disclosures we may provide concerning your account. It's not a violation of the deposit agreement or saying that the deposit agreement doesn't matter. To the contrary, Mr. Elizondo is standing on the deposit agreement, which told him to look for additional terms governing transactions like these in the documents that the bank provided to him.
If there had been $1 million in the account from other sources, and the bank received the wire transfer request from your client, is the bank in the same position as it is today? In other words, is your position that it didn't matter, it doesn't matter that there was plenty of funds to cover the transfer? By making any kind of a wire transfer, they then undertook the obligation to guarantee that all of the funds in the account were valid and couldn't be set aside due to fraud.
Right, I take the point, Your Honor, and I think that would be a slightly different issue because the text of the document says verified collected balance, not verify check number XYZ. But that's not what happened here. The bank's own document, the terms that it provided to Mr. Elizondo pursuant to the deposit agreement, which says look for terms on the documents that we provide to you regarding other services, they said that they would verify the collected balance. Turning back to the UCC, there's nothing that required Cadence Bank to immediately make the funds available to Mr. Elizondo. That's tab A of the bench book, UCC section 4.215. There was no obligation to make the funds available until Cadence Bank had received settlement from Chase. Federal regulations, regulation CC, there was no obligation to make the funds immediately available because this was a deposit of hundreds of thousands of dollars, over 90 times larger than the provision that Cadence Bank has cited dealing with making funds immediately available. That's for $5,250 or less. Nor does the deposit agreement require Cadence Bank to promptly make funds available. We've shown in tab C the parts of the deposit agreement that say the funds can wait. We can put a hold on the funds until we've received settlement.
But your position is that because they did not hold the funds, they became a guarantor of those funds regardless of whether the check turned out to be counterfeit. And for how long did they become the guarantor? Say that the counterfeit discovery was confirmed a year later.
Well, I think that raises two questions. The first goes to if they made a promise, then it's what the promise says. And the second is we aren't saying that the door is open to risk shifting indefinitely for the whole 3 years. The UCC sets forth time provisions in which Chase Bank would have been required to make the funds available to Cadence. And if Chase had actually provided funds to Cadence, then at that point Cadence would have had funds that it would have collected. And whether or not Chase could have clawed those funds back 3 years later, that's not the facts of our case. It's like saying, well, I'm going to ask my babysitter to lock the front door to keep out the biggest, most egregious threats of burglars coming in, but that's not a guarantee that someone won't come in through the window. But if the babysitter doesn't lock the front door and someone comes through, I mean, you stop the most obvious threats where they are. And the most obvious threats are that a check might not immediately clear. And that's what this contract had to do with. It had to do with that initial period in which you're waiting on whether Chase Bank will provide the funds. It's not a guarantee as to whether or not Chase Bank might claw them back 3 years later under a warranty.
But it's also a promise that it won't claw them back?
No.
Within the provisional time?
It is a promise that it has verified the amount of funds that it has collected in Mr. Elizondo's account, as opposed to a promise about whether or not a third party, such as Chase Bank, might have some competing claim to that. That's a different issue. The issue is just, have they received the funds? And it's undisputed that they did not. And I think that goes directly to the risk shifting that Cadence Bank has argued. Only Cadence Bank is in the position to know immediately whether or not the funds have been collected. In fact, Cadence Bank said at the closing part of its argument that there's no way to know. You can look at the available balance, but that doesn't tell you whether or not the funds are provisionally credited or not. The only way for Mr. Elizondo to immediately know, the reasonable way for him to go about it, is to look at the documents that Cadence Bank has provided to him.
And to that point, was something provided to him showing what the collected balance was?
It did not say what the collected balance was at the time that he saw it. It did represent that the bank would certainly verify the collected balance before wiring the funds. And I direct the court's attention to tab G of our bench exhibits. And it's sort of blurry in the copies that we have, but in the middle, there's a statement that says, all blanks must be filled in. Mr. Elizondo was told that this is what the bank would do before completing the wire transfer. It's a black and white representation of all blanks must be filled in. There will be a verified collected balance. Down underneath the approving officer section, he is told that they will be sure to have verified the collected balance. And I think Cadence has raised...
The number was filled in after he signed it, right? And he never saw the filled-in number that just went into the bank's file?
That's correct, but it was represented to him that they were going to do that prior to the transfer. And I think this gets to the issue of what is a promise. Cadence Bank has suggested, well, this is just an internal directive that our own officers were supposed to fulfill. The document never says that. It has a signature up at the top for Mr. Elizondo agreeing to terms. He's agreeing to the amount of time the transaction may take. He's agreeing to paying tracer fees. He's agreeing to a new and distinct amount of consideration for the wire transfer. And beneath it, but above where he knows Cadence Bank is to sign, there are terms governing Cadence Bank's obligation. They include the duty to verify collected balance, to complete the form correctly, and then to go forward with the wire transfer. And I direct the court's attention to the City of Houston versus Williams case that this court decided about 10 years ago. It dealt with the definition of how do we know if something is just an internal directive to a department or if it's a promise and a representation to the parties. And the City of Houston case dealt with some city ordinances that dealt with benefits for firefighters. And the court said, because the ordinances used mandatory language, the firefighters shall be paid X or shall have certain benefits, that was mandatory representations that the parties were justified in relying on as a representation as the City of Houston's commitment. It didn't require magic words such as, I promise that, or I contract that. It's just a mandatory representation that the parties are justified in relying on. How much more so here, where the bank provided the forms specifically to Mr. Elizondo. It's given to him, unlike an ordinance sitting on the record book somewhere. And as another example, just looking at other contracts, consider arbitration agreements, which are in employment contracts all the time. And the rule is that if a party has notice of the arbitration policy and continues working, that constitutes an acceptance. And I point the court to its decision in Dallas Peterbilt from 2006, where a party just said, I acknowledge that I have received and carefully read or been given the opportunity to read the arbitration agreement. There wasn't the words of promise. The court didn't require the magic words of I promise or I commit that or I contract that. It's just enough to know the terms. That's exactly what we have here. There's a reason why they provided terms to Mr. Elizondo, and he had every right to rely on the bank's representation that it would do what it said.
They promised to put a number in the box, but I'm struggling with where they promised to not send the money if the number in the box wasn't enough, or to take on liability that the law otherwise wouldn't assign to them.
The whole point of contract construction, especially in the UCC, it's a very pragmatic, practical tool for evaluating the parties' responsibilities. And those boxes would be absolutely meaningless if it didn't require what it says. for the bank to be sure to sign off, be sure to verify the collected balance before making the transfer. What's the point of verifying a collected balance if it doesn't matter what it is? The promise is that they're going to go forward with this prior to transferring the funds. And the truth of the matter is that they did not. It's undisputed that they did not verify the funds that were actually collected in Mr. Elizondo's account. The phrase verified does not mean unverified. The word collected does not mean uncollected. But they went ahead with the transfer.
I mean, from the perspective of the customer, it seems the bank could have all kinds of reasons for wanting to put various things in various boxes on a form and giving directions to its employees. And I just don't know that. I don't know that it's reasonable to assume that there's an obvious purpose to this. I mean, the bank, you have this terminology and these different forms, and I mean, who knows what their internal purpose is for wanting to put things on this form.
The issue is not their subjective purpose in putting the words on the form or their subjective understanding of the words on the form. The issue is objectively, the test under City of Houston, it followed the restatement. The test for knowing whether a promise has been made is, quote, it's a manifestation of intention to act or refrain from acting in a specified way so made as to justify a promisee and understanding that a commitment has been made. And when the bank, without any disclaimer saying this isn't a contract, it doesn't even say this is for internal purposes only. The heading says who's supposed to fill it out. It's the center function to fill it out, but it doesn't say it's for center functions only. When they say this must be done in all capital letters, they say that these are the steps that you have to be sure to take before undergoing the transaction. And they provide it to Mr. Elizondo. That's a representation to him of what they're going to do, that he's entitled to treat as a promise.
How is that construction of the form, how does that dovetail with the provision in the UCC that says that transfer warranties cannot be disclaimed with respect to a check?
Those are two very different things. The transfer warranty and a disclaimer, it would inject uncertainty into the entire banking process if a customer could write on a check, I disclaim all warranties, and then deposit it and expect that the banks are going to treat the check as valid or that he can later disclaim responsibility for it. A unilateral disclaimer or even a contractual disclaimer is a far cry from an agreement that a bank makes about a subsequent and separate transaction involving a different risk, the risk that only the bank is in the position to know of whether or not the funds have actually been received into the bank's account. That's something.
Well, there was no argument here that the funds were improperly wired by the bank or they went to the improper destination, right? The whole crux of it is the check, and that the check was counterfeit. So to say that they're completely separate seems to be inconsistent with the idea that a warranty that the check is good cannot be disclaimed. And I'm trying to understand how that's separate when that was the cause of the harm in this case.
It's undisputed that there is a cause of action for breach of the transfer warranty. That's why the trial judge, Wesley Ward, that's why the Court of Appeals held that the bank has a cause of action for breach of that warranty. The issue is there a separate cause of action for the bank's conduct in a separate transaction? That's how it's wiring funds out of the account. And yes, the two are very closely related temporally. They're related to the same amount of funds, but they're separate transactions. They're governed by separate parts of the deposit agreement. They're governed by separate parts of the UCC. That they are viewed as separate and distinct transactions. This isn't a disclaimer where Mr. Elizondo says, oh, I'm not making warranties. This is an assumption of an obligation by the bank with respect to how it's going to perform this wire transfer.
If the agreement, if we treat the form as an agreement as you contend, why should we consider it clear enough to vary the bank's obligations under 4.214 when the Federal Reserve Board of Governors has said the term collected balance does not have a uniform meaning within the financial services industry?
That's a very outdated, it's over 20 years, maybe close to 30 years ago statement by the Federal Reserve Board of Governors. We've assembled in our brief many cases, many of them much more recent, setting forth the definition of a verified collected balance or a collected balance. And it's understood as the funds that the bank has received. And there is some room for disagreement in other situations, such as suppose that Chase Bank had credited funds to Cadence, but Chase Bank still, it was just a provisional credit. In that case, Cadence would have collected funds, but they would be provisional funds. Is that a verified collected balance? It's not entirely clear, and I think that's what the lack of certainty that the Board of Governors may have been referring to. But when it's undisputed that nothing has been collected at all, which is what happened here, that is a facial violation of the bank's obligations that it's set forth in this document.
So we've all signed these forms before, you know, maybe it's the doctor's office or the DMV, or, you know, you fill out the top and we'll fill out the bottom. And it seems to me your position is, well, you the customer can look at the bottom that the other side's going to fill out and think to yourself, why do they want to fill this out this way? Like, what are they thinking here? And then you now have an agreement with them to do the thing that you think they're committing to do based on the way that their form is structured for their employee to fill out. Is that the position?
Respectfully, Your Honor, no. We aren't saying that Mr. Elizondo was entitled to guess about the bank's purposes. We're saying that Mr. Elizondo was entitled to rely on what the bank said it would do. As for its purposes, that's subjective purposes.
So where did the bank say that it wouldn't send the money unless it had been collected?
It said that it would verify the collected balance. In other words, it's going to make sure that the funds are there before sending them overseas.
Well, but what if it verified that the collected balance was $20,000? There's some reason Chase flagged an issue and said, look, we'll credit $20,000 on this for now, but we're going to hold back the rest. And so this bank, Cadence, employee fills out the form and verifies a collected balance of $20,000. Now, would it, under your theory, have breached something in this form by then sending the wire transfer?
I think so.
So the question is, where on this form does it say we're not going to send the wire transfer unless there's enough of a collected balance?
There is first the rule that terms must be given meaning. If these terms mean nothing, then what's the point? The second is the UCC. This is a UCC agreement, and there attaches the duty of good faith and fair dealing, so honesty and fact. The bank is going to have to fill this out in a way that accords with its duties under the UCC. That's the point of the agreement.
Any other questions? Thank you, Mr. Smith. Mr. Huttenbach, I believe you have 5 minutes.
Thank you, Your Honor. My opposing counsel said that the way the UCC works is Chase Bank does not, he says, there are time periods for Chase Bank to make funds available to Cadence. Now, I give the UCC update speech to a lot of banking organizations. I was just president of the Southwest Association of Bank Counsel. I might be having a moment, but that is not my understanding of the UCC. When you deposit a check, your bank gives you that provisional credit. When you go through the banking system, you then send that check through the federal banking system. You get a credit into your bank account for that amount. If the bank is not timely returned, you keep the credit. It's not we'll give you a credit in a couple days. You get the credit immediately. That's not what the other opposing counsel just said. And that's why I think it was Justice Bland, I think you made the point of what happens if they return the check a year later, because you get the credit originally. They might reverse the credit if they return it by the midnight deadline, but it could also happen again a week, a month, a year later if it's an altered check or all the other hypotheticals. The other question you asked.
If we were, I'll give you another one.
Okay.
If we were to agree with you that the parties cannot make an agreement that's inconsistent with the UCC's provision that you can't disclaim the transfer warranties that are in the UCC with respect to checks. If we give you that much, why wouldn't there be a mitigation defense here? Sort of, okay, we're going to uphold the warranty, but what you did contributed to the loss.
I get that. I mean, I'm an attorney. I feel bad for Mr. Elizondo for getting duped. At the end of the day,
No, as a legal matter.
Okay.
Is there a mitigation defense with respect to your breach of warranty claim?
not the way the current UCC is currently written. I mean, in 1996, they made some comparative responsibility, or they made some good faith or mitigation type of things to several of these defenses that banks have, but that has not appeared yet in these transfer warranties or presentment warranties. It could be amended, but this is the law that we have today. The way the American Dream Team case got around is they carved out, we're going to throw out all the common law, but we're going to leave in a fraud claim. And they kind of created that new law. I don't really think that's the right mechanism either. I think the legislature needs to amend the UCC and say, look, we're going to build in a good faith standard or a mitigation standard if that's the way the law is going. The other question that you raised to opposing counsel was, well, if there was $1 million in the account, how are you going to verify collected funds? What is the procedure even to mitigate? Well, do you have to go back? Because if checks can be returned for up to 3 years under the UCC, that's 4.111 and 3.112, I believe. And so if checks can be returned, if they're altered, missing an endorsement, forged endorsement, you're going to have to look at that bank account balance of $1 million, look at every single check to make up that balance and say, is that truly, finally, irrevocably collected? For every single check, let's say there's 150 checks in the account making up that balance. How are you truly going to determine, are those really, finally, irrevocably collected funds? And the big policy issue that I think the court should consider is, what are we telling bank customers? Is it okay to deposit a check under suspicious facts? This attorney does not do this type of commercial collections, never handled an international transaction. No attorney was involved. It was $1 million transaction. He did, again, 1 hour of work and expected to earn a $10,000 non-refundable retainer. The settlement terms that he was told, the debtor in that underlying putative transaction or purported transaction said, I owe $903,000. His client was telling him, I'm owed $1,080,000. So if he had accepted this check, is he costing his client $177,000 because there's no signed settlement agreement? And he was getting all these emails. My daughter is in the hospital. Please send me the money. Please send me the money. And this court said in the American Airlines case, it said that the UCC facilitates transactions benefiting consumers and financial institutions by allocating responsibility among the parties according to his best able to prevent a loss. Do we want customers depositing checks under suspicious facts, hoping they clear, get the money out of the account, and then I get to keep it if the money's gone? I don't have to ever pay it back. No, we don't want to encourage consumers to do that. And the UCC has rules in place to protect that. Thus, we should reverse and render, or if there's a contract issue, reverse and remand.
Any other questions? Thank you, Mr. Huttenbach. The case is submitted, and the court will take another brief recess.
All rise.